Good morning to all of you. Welcome to Legal Matters by Siva Vs State. In this video, we are going to discuss the evidentiary value of statements recorded under section 164 Cr.P.C. So friends, normally we will be giving much importance for them, and we are under the impression that section 164 Cr.P.C. statement is substantive evidence, but it is not. So please remember, Justice AS Vydyanathan and AD Jagdish Chandra of Tamil Nadu High Court, Vydyanathan, by now you might have understood. So, in the case, while disposing the case of Siva versus the state represented by the Inspector of Police in Criminal Appeal number 642 by 2018 on 22nd July 2022, right? While setting aside the conviction of a life accused or a murder case accused who was convicted for life, observed that the trial court erred, or the trial court was wrong. The trial court was misled in concluding that the statements of the witnesses recorded under 164 Cr.P.C. they were substantive, right? So first of all, let us know what is 164 statement. So recording the confessions and the statements, confessions of the accused and statements of the witnesses. Any judicial magistrate can record, whether he has got jurisdiction or not, can record any confession or statement made to him in the course of investigation, right? So please remember, the police presence should not be there. The magistrate has to give some cautions to him. Ultimately, yes, he is empowered to record the statement. Then what is the difference between ordinary statement recorded by the police under section 161 Cr.P.C. and the statement recorded by the magistrate under 164 Cr.P.C. is only the so-called sanctity. The court will give much credence to the statement recorded by the judicial magistrate. That too, he will caution him, he will take the signature, so many advantages of that. Definitely, it has got its own value, but it's not substantive. So, what is its value? The statement recorded under section 164 Cr.P.C. it is a corroborative piece of evidence. Then, what about the statements recorded by the police under 161 Cr.P.C? Yes, they can be used for contradiction and omission. They can use it for corroboration also at times. Right. Anyway, please remember, section 164 Cr.P.C. statement has got its own value, but not highest value. Right. Here, if you know the facts of the case, it will be easy for you to understand. Right. This case happened in the year 2010. Right. The deceased was having acquaintance, or at that time we can't call it as a living relationship. She was kept by the accused person. She was kept by the accused person, that is Mr. Siva. She is already married and having 3 children. This man also was married and having 3 girl children. So actually, we don't know the reality, but the accused asked her to transfer her property, her household property, into the name of 2 of the children, for which she refused. Then the trouble started. This fellow started beating her, saying that she has got some illicit contact like that, or suspecting her fidelity. Ultimately, and she reported the matter to the Mahila police station also in Tamil Nadu. This happened in Kanchi district. Yes, of course, before the police, they effected compromise, and they lived happily for some time only. Ultimately, on the dreadful night, that is on 29/2010, when the deceased was sitting in front of her house, the accused came there and asked her to go away from that place, saying that the house belongs to him, she cannot stay in that, for which she refused, and there was an altercation between both of them. Immediately, he picked up a wooden log and beat her on her head. And this was seen by PW1, who was standing opposite to the area. Of course, immediately she was shifted to local hospital. From there, she was shifted to Christian Missionary College Hospital, Raivellur. Ultimately, she breathed her last while undergoing treatment in the hospital. The police, as usual, they registered a case in crime number 272 by 2010 under sections 302 IPC and also 352 IPC of Thiruvalam PS. Thiruvalam PS. As usual, the accused was arrested and on his confession, the wooden log was also recovered, the charge sheet was filed. Here, 302, you all know, it's punishment for murder. What is 352? So, 352 is, please remember, assault or use of criminal force without provocation. This is more important. 352. Assault or use of criminal force otherwise than on provocation. Of course, it's a non-cognizable offense. The punishment is for 3 years. 3 years punishment is there. Right. The police filed the charge sheet. The trial went on. The trial court. In this connection, I want to tell you, all the witnesses turned hostile, including PWs 1, 2, 5 and 6, who gave the 164 statements, they turned hostile. But the medical evidence is corroborative to the FIR, to the narration of the witnesses. So, the trial court, basing on the 164 statements, because they cannot be contradicted. 164, the magistrate has come, he has come to the court and he stated that he recorded the statements, he has given caution to the witnesses, all these things. So therefore, taking into the recorded statements of 164 Cr.P.C as substantive evidence, since there is corroboration with the medical evidence, he believed the witnesses statements recorded on 164 Cr.P.C and convicted the accused for life imprisonment. Finish. So the matter has come to the High Court. Here we are discussing the case decided by the High Court of Madras, Justice AS Vydyanathan and A.D. Jagadish Chandra. Here, please remember, the trial court, even though it confirmed, High Court says the law is very clear. When the law makes it very clear that statements recorded under 164 Cr.P.C are corroborative and not substantive in so many cases. So the trial court erred in that particular regard. So, and another point, medical evidence, and they have decided the wooden log was recovered, recovery was there, and his shirt was having blood stains. No doubt it was sent to the chemical examination and it's proved that there is blood. But what group of blood? It's not decided. So therefore, mere presence of blood is not sufficient. Medical evidence definitely cogent. 164 statements, unless they are proved by the court in the presence of the witnesses, unless they say that these statements are recorded by the magistrate, then it is not due, it is not good to give conviction. The trial court erred in this matter. Right? The prosecution did not prove the case beyond all reasonable doubt. When there is any iota of doubt, the advantage should go to the accused. So therefore, the High Court deemed it not proper to convict the accused, as the trial court was misled by the 164 statements. So therefore, the conviction awarded to the accused was set aside and now he is free. So please remember, important point to note is that 164 statements are not conclusive. 164 statements are not substantive. 164 statements are only to aid or corroborative. That's all. Thank you very much.